Hey, a limited liability company may keep a tenant's lawsuit from reaching your personal assets, but that addresses only one direction of risk. If you're sued personally, what stops that creditor from pursuing your ownership interest in that LLC? Hey, I'm Clint Coons. I'm an attorney. I'm a real estate investor, and I'm going to attack this structure from both directions and then build that second layer stack that most investors are missing to ensure that their plan remains completely protected. All right? Let's get started. Okay, so when it comes to asset protection for rental real estate, what are most people doing, right? If you get on the internet and you do any searches or you talk to your friends, you probably hear this. Right now, you own a piece of property, it's in your own name, and you appreciate the fact that if something were to happen on this property, say a tenant is injured on the property, or maybe there's a contractor dispute, and I've seen this happen a lot. You bring in a contractor and the contractor then sends you a bill for twice what he quoted you. And he says, oh, there's all these overages that came up, whatever it is. Now you're involved in litigation. Here's the issue. The issue is that because this property is owned in your name, what does that do? That makes you the responsible party. All right, you are the owner of the property, so you now become responsible for that. Now, as a real estate investor or just somebody that has assets, you want to separate yourself from that liability. You do what most people do. You set up a limited liability company. So you create this LLC over here. And when you create the LLC, you have to have a member, you need to have a manager. So you will appoint yourself as the member right down here, that is the owner of the LLC, and maybe you'll set yourself up as the manager, or it could be a member managed LLC. It's really not relevant for this video. But what I want you to understand is that you then deed your property into the name of the LLC, which erases your name as the owner, and now the LLC is listed as the owner of that property. So if anything goes wrong with the property, again, going back to my tenants that are injured on the property, or it's a contractor issue, who do they sue? All right, they're going to name the limited liability company. Well, that was a mistake. See, they're going to name the LLC in the lawsuit. It's the one that's going to be listed as a defendant. Now, here's where the protection kicks in, right? You as a member, right down here, unless you've done something with that property that gave rise to that claim, maybe you were negligent in going in and doing some electrical work, which you should not do unless you're licensed, then you're not going to be held personally liable, meaning you're not going to be named a defendant in the lawsuit. There's no reason to name you as a defendant. So you think, great, the LLC is doing exactly what is intended to do. What happens inside of this box stays inside of the box. It's contained. It's a container. Now, what most people are missing, and I see this all the time when I work with investors, they come, they meet me at an event, they will tell me, hey, I've created this structure. I have a few LLCs set up. They own property. What do you think of my protection plan? The very first question I ask them is, do you own that LLC directly? All right. Are you the member in that LLC? A lot of people don't even know that answer to that question, but again, side issue. So most people will say, yes, they are the member, right? When we get down into it, we start looking at the operating agreements, we find that the individual who owned the property, these are the same individuals, right? It's you. You own it in your own name. Now you own it through a limited liability company. You're the member of that LLC. Now see, this asset protection plan that you built for yourself, I've just identified for you the weakness in it. See, when you're a member of that limited liability company, you want to ensure that your ownership interest, okay? So when you're a member in an LLC, you have a membership interest, okay? Membership interest. You have to make sure that this membership interest here is also protected. Now, why is that important? Okay, what a lot of individuals do not understand is that liability is a two-way street. That means you have issues that can happen in here. We'll call this inside liability. What happens in that box stays inside of that box. But what most of us are missing with our structures is protecting the box from what I'm going to refer to as outside liability. Okay, and so what is outside liability? Outside liability is where you yourself are involved in a lawsuit and someone is suing you personally, and they get a judgment against you. Now they obtain this judgment. What does that mean in the hands of a creditor? What it means is this. is that if I get a judgment against you, I now have the ability to bring you in to a debtor's exam and start examining your assets to look for a path for recovery. You see, a lot of individuals assume that through the process, the legal process of you being sued with, let's say it was a car accident, that opposing counsel can ask you about your assets. Hey, do you have any real estate? Do you have any business interests? Do you have a personal residence? How much do you have in your savings account? Listen, all that is off limits. They cannot ask those types of questions. Well, actually, they can. You don't have to answer because those questions are not relevant to whether or not you were negligent when you were driving or distracted, whatever it is. So where it becomes relevant is after they have a judgment against you. So let's keep with that scenario right now. Let's assume it was a car accident. In fact, it wasn't even you, it was your daughter who got in the car accident. But since the car is in your name, you're going to be liable. So they sue you, someone's suing you. Here's a creditor over here. They bring a lawsuit against you, and ultimately they obtain a judgment against you for $350,000, okay? So they get this judgment against you. The first thing they're going to do after they obtain the judgment, typically, is they're going to bring you into this debtor's exam and they're going to say, what do you own? And so now you have to list out all of your assets. I have a savings account, okay, with $50,000 in it. I have a personal residence, okay, and currently it has $125,000 in equity inside of it. I have 2 LLCs that own real estate, and that real estate has combined equity between those 2 LLCs, those 2 properties, $375,000 in equity. And you go on and on and on. You list these assets. Now, the creditors want this information because now they're selectively going to choose how they're going to recover their $350,000. So what they're going to take first is a low-hanging fruit, which is the $50K. They'll garnish your savings account. They'll probably leave your personal residence alone because most of us have homestead exemptions that exceed that, so there's nothing they could collect there. But you're going to pique their interest with this right here, the $375 in the LLCs, which you probably thought was protected. But again, you're protected from what happens here on the inside. So what are they going to do then once they find out you have these LLCs? They're going to do this. They're going to move the court to foreclose on your LLC, okay? So what does that mean, foreclose on your limited liability company? Well, it means just like what would happen with real estate. When you foreclose on someone's membership interest in their LLC, you're essentially going to take it, okay? You're going to, well, that's not actually how, technically what happened is the sheriff's going to put it up for sale, and then you're going to bid your debt. And if no one bids higher than you on the LLC, then it becomes your LLC. And I can tell you what, in my experience, people don't bid on LLC membership interests. It's just not a common thing. So it typically goes to the debtor. So the debtor then walks away with your LLC interest unless you can outbid them. So let's assume that you bid $400,000 for your LLC, then the creditor, you would have to pay the creditor $350,000, which is what they're owed right here, and then you would keep the $50,000 for yourself. But most people don't have that cash, so they're not doing that. So ultimately what happens is that your LLCs are taken. The creditor now obtains your LLC. So see, this is the problem that no one's talking about, no one's thinking about when they're creating their structures. And you may have done this already. You've got these great LLCs set up like this for asset protection purposes, protecting your real estate, but your overall system has you right here. You're the weak point in your structure. Now, this is remedied. Okay, how do we remedy this? It's something we do here at Anderson. We've been doing it for 27 years for our clients, recognizing that if you're going to create a structure, I want to make sure that I'm protected what happens with my real estate, but also that my real estate LLCs are protected from my personal creditor claims. And so this is where an additional LLC is warranted. And so what I want to do is I'm going to replace you. And instead of you being the owner of these LLCs, we are going to use a Wyoming LLC. Now this works from the outset when you're building your entity stack and you're creating your system to protect your assets, or if you already have these LLCs, you can bring this in after the fact. So And that happens a lot with many of the clients we work with. They don't have this to begin with, and then later on we bring this in once we identify the weakness in their overall plan. So what you're going to do here is you're going to create an LLC in Wyoming, and I'll explain why that is in just a moment. But it's just a standard limited liability company you set up in Wyoming, and you will be the member of your LLC, and you're going to be the manager of this LLC. All right, so you're going to be both. Now, when you set up this Wyoming LLC, I want you to take your existing LLCs and move them to the Wyoming LLC. Now, what do I mean by move them? Okay, so when I say move, okay, to Wyoming LLC, what I'm saying is that you need to assign your interest, okay? It's called an assignment of interest. In fact, here's what I'm going to do for each and every one of you that are watching this video to this point. If you set up a Wyoming LLC and you need to assign your interest, in the show notes, I will have a link to an assignment form, okay? And it's really simple. All you have to do is complete that form assigning your interest. So it would say, I, Clint Coons, hereby assign 100% of my ownership interest in Turtle Space LLC to Kingdom LLC. So I move Turtle Space into Kingdom just by that one piece of paper. If you sign it, you don't have to record it anywhere, right? Now what you've done is you've gone from being the original owner of Turtle Space, and you've said, all right, now I'm going to make Kingdom the owner of this company. So I am no longer considered to be a member. Now that is the critical step in this whole plan right here. You need to make the Wyoming LLC, Kingdom, the member of all your limited liability companies that own your real estate. Now, why is that? Why am I telling you to do this? Well, remember I just shared with you back here that if a creditor came after you, they could do this right here. They could foreclose on your LLC and take your membership interest. Why is that? The problem with these LLCs up here is that the state law where you created these LLCs, many times they have remedies that are creditor friendly, meaning that the creditor can take control of your LLC. The creditor can foreclose on your LLC and take it from you because that's baked into the state law. If you were to look at California statute, it states right in the middle of the statute, and this is familiar, a lot of states have this in their statutes. It says, hey, foreclose on the LLC. If you have a judgment against a member in an LLC, if you're a creditor of that member, you can take their LLC from them. So knowing that, what you need to do then is find a state that does not recognize that type of remedy. So what you want is a state that does not allow a foreclosure, does not allow someone to take control of your LLC. And there are really three powerful states out there that protect assets. The gold standard is Wyoming. Okay, that's Wyoming, Delaware, and then Nevada. Nevada, you don't get anonymity, so that's a problem there. But Delaware and Wyoming both provide you with anonymity. I like to use Wyoming because it's less expensive to maintain an entity there. So we set it up in Wyoming. Now, what is it about Wyoming that's protecting these LLCs by when I transfer them out of my name? You see, now, if that creditor brought me in to this debtor's exam and they said, how many LLCs do you own? Well, before, in my example, actually I only drew one. Let's say you had 2 LLCs in your name, so make it match. I would no longer tell them I own 2 LLCs. Instead, I would tell them I own 1 limited liability company, all right? And that 1 LLC owns 2 LLCs. And those 2 LLCs own real estate with the equity that I described, $375,000 in equity. Now, here's the problem for the creditor. The creditor's judgment is against you personally. And the only thing the creditor can attach or go after is whatever you own. So in my structure over here, how many LLCs do I own? I only own 1, right? I own this LLC right here. I don't own these any longer. I transferred those LLCs into Kingdom. Kingdom is the owner of the LLC. So when you're asking me, what do I own? I'm just going to say, hey, I own 1 limited liability company. It's Kingdom. And that is the only thing the creditor now can attach. So then what the creditor needs to do is they need to look at Wyoming law and determine what remedies are available to a creditor of a member in an LLC. And this is where it gets really interesting. You see, Wyoming, in their statute, it states that a creditor's remedy is limited to this term right here. It's called charging order. Okay, that's it. That's the only thing they can obtain. And so what does that mean? Well, it means this, as far as I'm concerned. They can't touch my structure. They cannot take my interest in kingdom. There's no foreclosure. There's no ability to manage my LLC. In fact, the statute's so forward-thinking is that when they drafted it, they even recognized single-member LLCs, and they said, hey, it doesn't matter if it's a single or multi-member. The only remedy available is a charging order. And so what this means is that the creditor sits right down here. So here's your creditor. Your creditor then has a lien on your interest. And that lien only impacts distributions you pull out. So if you decide to take a distribution out of your LLC, well, you'd have to pay that cash over to your creditor. But as long as you're not taking distributions, your creditor is not receiving any payments against that judgment. And so the creditor could just sit there and never get paid. So this charging order is protecting your ownership interest. And I have people, when I tell them this, they say, well, Clint, that doesn't make sense. Where's the benefit here? Because I can't take out money out of my LLC because I have to pay it to my creditor. And I said, well, before I tell you how you can take money out of your LLC, think about it from a different perspective. Without this level of protection, if you stayed in this structure right over here, which looks ugly as hell, okay, if you stayed in this structure with the two LLCs and you were the only member here of your LLCs like this, then I guess distributions would no longer be in the forefront of your mind, because in that lawsuit, your creditor, in order to get paid, would have removed these from your asset base, meaning they would have taken them. So if you want to live in a world where you don't have to worry about distributions and cash flow because you no longer have assets, most definitely keep the assets in your name. Now, when I put it in those terms, people are like, oh my gosh, you're so right. So what does this do for me? How do I gain access to my cash, right? That's a question you're probably thinking of. Well, what you do is you have two options. You can loan yourself money, or you can pay yourself a management fee. All right. Either one will get you access to your assets, and it's not considered to be a distribution. But that's for a different video. The point is that I want to share with you here in this video is that by putting together this holding LLC in Wyoming, you're protecting against creditors sneaking in, suing you, and then getting access to your assets. I oftentimes refer to this entity right here, this Wyoming entity, I like to call it a blocker entity. Because not only does it provide this level of asset protection as the blocker entity, it also provides anonymity for you. So that means that these LLCs right here do not point back to you. They only point to the Wyoming LLC. And this adds an additional level of protection for you from outside creditors, meaning a statement that I use many times is that you don't get sued for what you did. You get sued for what you have. And if a creditor is thinking about, or attorney that is thinking about bringing a claim against you and they run an asset search and they cannot find assets in your own name because you've used structures like I'm just describing here, you've created a system around your assets to make sure they're protected and they're removed from public records so you're not considered the owner, well, the threat of you being sued has gone way down. And that's what we want to do when we're creating asset protection structures. I know a lot of people talk about, oh, set up an LLC or do this or that. But what I feel most of them are missing is that they're focusing on the claim that happens with the asset and not considering that you yourself could be sued because of things that you do in your everyday life, and that puts your assets at risk. Hey guys, I hope you liked this video and you now understand what you need to do to improve any structures you currently have, or if you're building a new asset protection structure, start with that Wyoming LLC as your base foundation and then build up from there. That's the optimal way to put this together. But nevertheless, you need to take action to get something in place, because when that lawsuit arrives at your doorstep, you'll definitely be thinking, wow, I wish I would have done this before this happened, because at that point in time, it's too late. Now remember, I said I have a link in the show notes so you can obtain that assignment of interest form. Be sure there to go and grab it. Also, if you want to talk to someone here at Anderson, one of our senior strategists, about creating a plan like I've just drawn out for you here and see how it would apply in your situation, Go into the show notes. There's a secondary link in there where you can sign up for a free strategy session, 45-minute strategy session. Not only talk about asset protection, we'll also discuss some tax planning strategies that I'm sure will put more money back in your pocket here this year. All right, I tell you this, I wish you the very best with your investing. Take care.